Hello everyone. Today is the second video in the law series. So today we are going to discuss essentials of a valid contract. As you can see in the very first slide, section 2 clause H of the Indian Contract Act 1872 defines contract as an agreement enforceable by law. Also, Section 2 Clause E of the same Act defines agreement, that is, every promise and every set of promises forming consideration for each other, and this is called an agreement. So basically we can say that an agreement is a promise and a promise is an accepted proposal. See, we can also see the definition of promise under section 2 clause B, which says when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted, and a proposal when accepted becomes a promise. It clearly says that an agreement is a promise, and a promise when it is accepted, it becomes a accepted proposal. Also, this means that every agreement is made up of a proposal, right? Proposal from one party and is acceptance by the other party. That means there must be two persons or more than two persons, right? Because one person cannot enter into an agreement. Why? Because there will not be an offer and acceptance, right? So this is the analysis of the definition of a contract under the Indian Contract Act. Now, there is a very famous saying, as you all know, every contract is an agreement, but every agreement is not a contract. That means all contracts are agreements, but all agreements are not contracts, right? So an agreement, as we can say, it is a wider term, a term wider than a contract. Why? Because every contract is an agreement, but on the other hand, every agreement is not a contract. Okay, because uh, you know when an agreement becomes a contract, some essential conditions need to be fulfilled, and those conditions are satisfied under section 10 of the Indian Contract Act. As you can see, section 10 reads as what agreements are contracts, right? What I'm saying is clearly written here. What agreements are contracts? All agreements are contracts if they are made by the free consent of parties competent to contract for a lawful consideration and with a lawful object and are not hereby expressly declared to be void. Now, see, the key points which have to be noted here are number one, the free consent of parties, right? That means the consent of both the parties should be free, right? The parties who are entering into a contract. See, we will also discuss in the upcoming videos the meaning of free consent, right? But free consent, we can say it means that, both the parties are freely entering into a contract, right? There is no dominance, there's no undue influence, no coercion or force by one party upon another to enter into a contract. Okay, then it is also written competent to contract. That means only competent persons can enter into a contract, and everyone is not competent, right? If we interpret this term competent, why? Because under the Indian Contract Act, a minor, a person who is below the age of 18 years cannot enter into a valid contract, right? This is just an example to let you know and to explain you what does the term competent means. Okay, that means also a person who is of sound mind, right? He's not lunatic. Okay, we'll discuss all these terms in the upcoming videos in detail. Another important key point of this section 10 is lawful consideration, right? That means the consideration, the price, for which the promise of the other is brought, it should be lawful. Okay, this also we are going to discuss in detail. A whole topic on consideration we will discuss. Now another key point is lawful object, right? That means an object should be such which is not forbidden by law, right? It should not be fraudulent. This also we'll discuss in details. Okay, and then it is written, and are not hereby expressly declared to be void, right? That means an agreement by way of wager, right? Restraint of trade, marriage, all these agreements are void, and these agreements cannot become a contract. Okay, now see, please remember that in order to make an agreement become a contract, these conditions need to be satisfied. Now, what are those conditions? Number one, offer and acceptance, right? That means one party is offering to the other party, right? And that other party is accepting the offer, or the one who is proposing. So, offer and acceptance should be there. Then there should be an intention to create a legal obligation, right? Now this term legal obligation, this also we are going to discuss in detail, right? See, in Indian Contract Act there is no provision that requires, that an offer or its acceptance should be made with the intention of creating a legal relationship, right? On the other hand, in English law it requires, all right, but in Indian law there is no provision as such. However, there is an intention to create legal obligation, and this is an essential term, right? So that a valid contract is created. All right, now what is intention, what is legal obligation? So basically these terms can be ascertained from the terms of the agreement, right? We'll discuss this point in detail, but for now, you need to remember that in order to make an agreement a contract, intention to create a legal obligation should be present. Okay. Third point is consideration. Now, see, consideration also we are going to discuss in detail, but it means that, a price for the promise, and that should be present in the contract. Then it says parties are competent to contract. That means, as I said, like a minor cannot enter into a valid contract, right? Or any person who is disqualified by law, right? An alien enemy, for example, these persons are not competent to enter into contract. Consent should be free, right? That means there should no be coercion, there should not be any fraud, misrepresentation, undue influence, or mistake. Okay, there should be lawful object. What do you mean by lawful object? Means the object of an agreement, it should not be forbidden by law. It should not be fraudulent. It should not be opposed to public policy. Okay. Next point is agreement must not be expressly declared to be void, right? That means in Indian Contract Act there are few agreements that are void. For example, by an agreement by way of wager, an agreement in restraint of marriage, in restraint of trade, all these agreements are void. So these agreements cannot become a valid contract. Then the next point is terms must not be vague. All right, that means the terms should not be uncertain. This condition we will discuss under section 29 of the Indian Contract Act 1872 later in the upcoming videos. All right, then agreement must be capable of performance. It means that an agreement should be such that the parties are capable enough of performing that agreement, right? Because if an agreement is made to do something which is impossible, then it is void. Okay, this also we are going to discuss in detail. Last point is legal formalities, right? That means when we talk about legal formalities, we can say, and a contract should be in oral or it should be in writing, right? It should be registered in some special cases, right? For example, if there is an agreement to make a gift, it must be in writing, it must be registered as per section 25 of the Indian Contract Act, right? So these are some of the legal formalities which need to be present. Now see, there's a very famous jurist, Salmon, right? He said that, uh, the law of contract is not the whole law of agreements, nor is it the whole law of obligations, right? That means only those agreements or contracts which give rise to legal obligations. Okay, it is a law of those agreements which create obligations, and these obligations which have their source in agreements. Okay, so we can say that, the law of contract deals only with the agreements which become contracts and not with all the agreements. Okay, so Salmon has, discussed this point in a summarized manner, that only those agreements are contract which give rise to legal obligation. The last slide. Now see, these are, following cannot become a contract. Like, all legal obligations are not contract, right? Only those legal obligations that arise out of agreement can constitute contract. So these obligations, right, like civil liability for torts, breaches of trust, quasi contract, judgments of courts, recognitions, status obligations, all these are not contract. So today we have discussed the essentials of a valid contract in much detail, and all these points, the key terms which I have told you today, we are going to discuss one by one in the upcoming videos. So thank you for watching. Thank you so much.